We got testimony coming up here on Senate Bill 323. First of all, before we get started, are there any bill introductions, either from the committee or from the audience? Seeing none, just a note to those who are watching online, you can go to legislature.org, look for the committees tab, the standing committees tab, click on Senate, click on the number 2, and then go down to utilities, and then look for the committee testimony, and there will be a little date box. You just click in the date box, and the 26 is highlighted, so you'll be able to see the PDFs of those documents from those presenting today. As I said, we've got Senate Bill 323. This is establishing requirements for instruments that convey a wind or solar lease or easement. And to start, I'm going to have our reviser, Nick Myers, come up and give us a brief on this bill. Nick?
Thank you, Mr. Chairman, and good afternoon, committee. Again, my name is Nick Myers. I don't know if I've introduced myself to all of you on the committee, but Nick Myers with the Reviser's Office. And I've, just a little background on me, I've staffed House Energy, Utilities, Telecommunications Committee for now my 9th session here, and I've been with that committee all 9 sessions. And now I'm with you. Committee, as the chairman said, Senate Bill 323 is up today, and I believe you may have access to my bill brief on the matter. So what this bill would do is that it would require, prior to the construction of any wind or solar generation facility, that the written instrument that's conveying any lease or easement for that facility has to meet certain requirements. So first, what the bill would require is that lease or easement instrument contain a cover page with a statement in 16-point font notifying the parties and specifically the landowner of some allowances that the landowner is able to do. The notice gives the landowner, states that the landowner will have sufficient amount of time to thoroughly understand the document, explains that the landowner is strongly encouraged to hire an attorney, and that the landowner can talk with neighbors about the project, and that the neighbors can agree and the landowner can agree to hire the same attorney on the project. Additionally, this instrument, the lease or easement instrument, must be held for at least 10 business days following the first delivery of that instrument to the property owner. And that lease or easement instrument at the onset has to be free from any non-disclosure agreements to apply to that landowner. The bill does allow for non-disclosure agreements to be incorporated into the lease or easement instrument if it's later mutually agreed upon in the final instrument by the parties. Additionally, the bill would require the developer of the facility to enter into a facility agreement with the landowner prior to the execution of the lease or easement. And there's requirements in the bill of what the facility agreement must contain. So this facility agreement would preserve the right of the landowner to continue to conduct business operations, except for making reasonable accommodations for the wind or solar facility operation. This agreement would prohibit all parties to the agreement from collecting any hunting fees on such property. It would require the developer, owner, or operator of the facility to comply with both federal and state law and not make the landowner liable for any such legal violations. This agreement would allow the landowner to terminate that agreement if the facility is not operated for 3 years, unless the landowner continues to receive normal minimum lease payments during that period of time. The agreement would also state that it must clearly provide in writing the circumstances that may allow payments to be withheld from the landowner. And finally, it would require the developer or the owner and operator of the facility to carry general liability insurance for claims that arise from property damage or injuries. The bill finally would authorize a court to alter or void any lease or easement that does not comply with those requirements. And Mr. Chairman, I believe that's a good little summary of the bill, and I'd be happy to stand for questions.
Committee, Senator Peterson.
Thank you, Mr. Chair. Would this prohibit the landowner from having that ground and walk-in hunting?
So what the bill states is that the landowner, neither party can collect any hunting fees. So in subsection A, paragraph 4, capital B, from collecting any fees for hunting on the property. So I presume that if the landowner is not collecting any fees on the property, there could still be some hunting on there.
I was wondering if, the state walk-in hunting program pays him to allow the walk-in hunting. That's what I was referring to.
Oh, I'd have to look into that a little bit.
If you would, I'd appreciate that. Thank you.
Committee, any other questions? Senator Warren.
Thank you, Mr. Chairman. In section 1, it talks about any written instrument that conveys any estate or interest. So does that language then refer to the actual deed or the recorded instrument and not necessarily a contract? Because a contract can create rights between the parties, but wouldn't be an instrument that conveys the land, or if you're understanding my question.
Yeah, this pertains to those written instruments that are conveying that making that property transfer, that property conveyance. So the actual lease or easement document.
That would be recorded with the county, and is that what we're talking about, or are we talking about just the mere contract between folks, or all of it?
It's specific to that land conveyance, and I
So.
presume that would be recorded within the county Register of Deeds office as well.
Okay. Thank you, Mr. Chairman.
Any other questions? And this would be prospected going forward, correct, Nick?
This
For any new land leases?
yes, it would be prospective. It doesn't apply backwards. It's prior to the construction of facilities is the in section 1, that first language. So yes.
All righty, cool. Any other? Yes, Senator Warren?
Thank you, Mr. Chairman. On page 2 of the bill, it talks about at subparagraph D, allowing the landowner to terminate such facility agreement. Do we have any explanation of how a facility agreement, if that's different than the written instrument that's been recorded and conveys a land interest, and is there a conflict there, or what does that look like?
So I think going back to your prior question, this facility agreement would be more of an agreement between the parties, more of a contractual agreement, not the actual land transfer. But the bill does require this facility agreement to be included as part of what's recorded, of what's the lease or easement instrument. So this would be a contractual agreement between the parties that could then later be withdrawn according to that subparagraph D, and that agreement could be terminated.
And the bill doesn't require any action regarding a different deed to convey the land back or convey the land anywhere. Is that the status of the bill we're looking at?
So in subsection B of the bill, the bill does require that a facility agreement be executed with the landowner. And as you noted, paragraph D, or subparagraph D, I should say, states that a landowner can terminate that facility agreement. So a facility agreement's required. Subsection B does require that if the terms of any easement or lease are not found to be in accordance with this section, a court of competent jurisdiction could then alter that easement or lease to achieve compliance with the section, void the easement or lease, or then order any other equitable relief as authorized under law.
Thank you.
Senator Francisco.
Thank you, Mr. Chair. So I'm aware that there are some solar installations where essentially the equipment is leased to either a property owner or a leasee, say the roof of a grocery store. So this would be a solar energy system, including those devices. It doesn't say that it has to be for outside sale. And so how is there any different way that would affect that kind of a lease that's not just a land lease for building, but in fact a lease for someone using your own property, so that you can lease the equipment rather than have to purchase it?
So you are correct. The definition of a facility does include a solar energy system. And I believe you're referring to a solar energy system that is more used to offset your own use of electricity. You're correct. This definition does not have a provision to exclude those types of solar energy systems that are predominantly used to offset your own electricity use. So I would say that it seems to cover those types of systems as well.
Would we may have to look at, because it was for industrial use, the big stuff, not the rooftop stuff. Any other questions, committee? Thank you, Nick. Appreciate it very much. We have 2 proponent in-person testimonies and 1 opponent. So I'm going to portion the time 10 minutes each, and so we can allow for questions. We'll have our proponents first open for questions, and then opponent and open for questions. So I'm going to turn it over. Our first in-person is Bill Skopp, and introduce Bill. And if you'll just introduce yourself, Bill, and thank you, sir.
Sorry about that. In the leasing industry, primarily in equipment, but also in some real property leasing as well. I am here as a proponent of Senate Bill 323. Senate Bill 323, I believe, is a crucial step to protecting Kansas landowners' rights, and that's specifically related to industrial energy development and the real property leases that are pushed upon trusting and, if not naive, landowners by the industrial energy developers. This includes both industrial wind and industrial solar. I'm not an attorney, so I'm not here to try to convey any sort of legal advice or legal review, but I can tell you I've spent a lot of time in the leasing world. I've seen a lot of interesting things in that world, and I'm here to share some of my perspective as a concerned, invested Kansas landowner and a citizen. I have had the opportunity to review an industrial wind development lease that was proposed in Lynn County, Kansas. I believe that same lease was used in other counties within the state and, in fact, executed by a number of landowners within those counties. The proposed agreement has been reviewed by an attorney, so we have had a legal high-level view of that agreement, so we have some reason to believe there are a number of major concerns with it and major concerns and risks that are pushed upon landowners by virtue of executing that agreement. There just isn't enough time to try to address all the concerns that are there, but I think it's important to understand that the focus of Senate Bill 323 is to allow for open and fair disclosure and dialogue among landowners who are presented with a land lease by an industrial developer and more importantly, it provides for a reasonable amount of time for those landowners to have a chance to seek legal counsel and to make a reasonable and rational decision. You know, logic and common sense would tell you that landowners would be free to consult with their neighbors and discuss freely a specific lease agreement, including anybody who's involved in participating in a proposed industrial development. But that isn't really the case. Most industrial energy development leases include extensive confidentiality clauses that restrict the landowners from discussing any part of a lease agreement that they have executed. And this includes anything related to land use or even a monetary or proposed monetary benefit that they may receive. And those confidentiality clauses go further to enjoin them from even discussing certain post-lease signing activities or actions of that tenant or industrial land developer, or industrial energy developer, excuse me. I think we all understand that these industrial developers have a very large economic investment in these properties, but in my opinion, it pales in comparison to the risks that it places not only on the landowners, but on the counties and on the state itself. Included in some of those risks are a host of major risks, including landowner health, livelihood of the operators of that property. And there's even restrictions within those agreements that limit the accountability of the developers to the landowners over the course of that land lease. The complexity and scope of that tenant-generated or industrial energy developer drafted agreement is honestly mind-boggling. 57 pages long is the agreement I reviewed. 57 pages. The only reason you'd have an agreement with 57 pages is if one of the parties is trying to push every imaginable or conceivable risk onto one party. And that is exactly what goes on with the agreement we saw that was being proposed in Lynn County, Kansas. In my opinion, there was absolutely nothing even reasonably equitable or mutually beneficial about that agreement because of the language that was in there. You know, in my 37 years in the leasing world, I've seen an awful lot, but I've never seen an agreement more egregious or one-sided than this land lease. It places literally all risk and unlimited risk on that landowner, and at the same time provides almost unlimited indemnification to the wind developer from any liability whatsoever. Again, the agreement lacks anything that you would expect to be a reasonable and mutual benefit between a landowner and that industrial wind developer, which is exactly why it's imperative that this committee take action to, at a very minimum, provide a cautionary note and encourage anybody, any person, entity that's considering entering into an industrial land lease or an industrial energy development lease to seek qualified counsel before agreeing to that agreement. The lure of what appears to be easy money and the developer-created time-sensitive pressure to execute that agreement could lead to devastatingly bad outcomes for any property owner who does not really fully understand the ramifications of the lease contract they're going to enter into. And this includes the loss of simple landowner rights that you would expect a landowner to hold even after a lease. And it also imposes, in my opinion, undue risks on not only the county governments, but also on the state. In my opinion, it's crucial to understand that these development leases do not treat landowners equally, which is part of the reason you see confidentiality agreements in those leases. They allow and grant for the developer to take what are essentially unlimited easements beyond the footprint of the base energy device. In the case that I looked at, it was a windmill. Those additional easements that are granted by virtue of that land lease include rights to add an unlimited number of buildings, to add roads, to change drainage on the property, to install power, transmission lines, install substations. The scope even goes beyond that to the point where it allows a developer to take and use water on the property, remove trees, reroute riparian strips, and potentially even limit a landowner for using his property for agriculture, fishing, hunting, and even their agricultural livelihood. It's exceedingly important that landowners understand not only the ramifications of their lease to their property, but also to have a reasonable opportunity to understand the larger picture. And that includes understanding what other potential participating landowners may be agreeing to and what impact those leases may have not only on their property, but other property owners within the development. Senate Bill 323 provides at a very minimum a notification to any owner considering participation in a lease to be diligent and proceed very cautiously. I urge all of you on this committee and anybody who will be voting on the bill to put Kansas and the very landowners that have made the state great first. Move the bill forward, sign it into law. At a minimum, this bill will afford free and open discussion among landowners about the risks they legally bind themselves to by virtue of the land lease that they would enter into. And it provides for fair and open discussion on the long-term impact, not only to their land, but land belonging to their neighbors who may not participate in an industrial development. The long-term ramifications of those developments could have generational changing effects on the property owners, even if somebody elects not to participate in an industrial energy development. Again, I encourage you, move this bill forward, sign it into law, and I thank all of you for the opportunity to speak today.
Thank you, Bill. I think what we'll do is hold questions until after the second proponent, and then we can open it up to Bill and Bev Kavoris, who is our next proponent. Beverly is online, and I'll allow you to introduce yourself, Beverly.
Can you hear me?
Yes, very
Okay.
good.
Chairman Thompson, members of the Senate Utilities Committee, I am a proponent of SB 323. Thank you for inviting and welcoming us to provide testimony. I was born and raised on a farm in McPherson County. My parents were farmers, as were 2 generations before them. Aside from spending 10 years moving from place to place with my Air Force fighter pilot husband, I've lived in Kansas all my life and own several parcels of land. I was going to insert a little bit about myself. When I found the time frame was not going to fit, I'm going to move this to the end, and if I have time, I will go through that with you. McPherson County is zoned and has a board of planning, zoning, and appeals. We have had 5 major international companies try to establish commercial, industrial, wind, and solar generation plants in the area that we live in, starting in 2004 and lasting to the present. The solar has been more recent, but the wind generation started in 2004. The companies were from US, France, Spain, and Italy. The 2 largest wind projects leased roughly 44,000 acres each back in the years of 2016 to 19. Roughly 100,000 acres have been leased to McPherson County over the years. That is 156 sections of land, and I estimate 100,000 to be on the low side. All 5 projects have failed in our county and were never built. One company alone was planning 208 600-foot industrial turbines in the northeast quarter of our county. It's the most beautiful part of the county and is home to Kansas Department of Wildlife, Parks, and Tourism managed properties, Maxwell State Lake and Game Preserve, Prairie Trail Scenic Byway, and the area has many different species of wildlife that we treasure. One wind company leased land right next to those Kansas Department of Wildlife and Park properties, ignoring the 3-mile setback recommendations by the department. Our county has, as have other counties in our state, major military training routes with classified issues that conflict with 600-foot turbines. After 2 years of communication, education, research, and action taken by our Carlo group since August of 2018, our Board of County Commissioners implemented a total prohibition or ban of industrial wind projects in December of 2020. And as of December of 2021, McPherson County has a ban on industrial solar projects for 2 years. Prior to this ban, I served on the Solar Study Committee in our county, along with several others from our county. That involved a lot of research that we were supposed to give to the county commissioners. After 2 years of communication, education, research, and action taken by our Carlo group since August of 2018, our board of, oh, I'm sorry, I got mixed up. A special concern that I have is the fact that wind and solar companies prey on unzoned counties and landowners who own land near transmission lines. Oftentimes, the companies lease the land, make the deals with local officials, and are ready to start building before any of the non-participating landowners and citizens of the county are even aware of what is happening in their very own county. After studying this bill, I believe it would be a good start to what all counties need in our state in order to protect landowners who are considering signing a commercial, industrial, wind, or solar lease, and those who don't. The following list outlines my questions, concerns, and possible amendments to this bill. We know there will be opposition from others, most who stand to gain financially, and please remember that as you consider the following. Transparency is so important. We need a mechanism for these projects to become public before any leasing begins and before any meteorological towers can be approved and built. We need hearings and requirements met before any land leasing or building is allowed to commence. Regarding failed wind projects, of which we have many in our county, add fines for companies who do not terminate leases when their projects fail. In our county, this was promised in a letter to leaseholders from one company. The termination of leases at the Register of Deeds office was to be completed in August of 2020. And this process has not been completed nearly a year and a half later. Landowners need to have clear title restored to their land. Ultimately, it is the responsibility of all of you, our elected officials in the state of Kansas, to protect the safety and welfare of its citizens from harm. Right now, that is not being done, and citizens are left to their own devices to fight something so big and massive that they do not even know where to start. For most, by the time they find out what has been going on, it's already too late. They've already been stormed by savvy, wealthy companies who are used to getting their way. Like in football, we need a referee. This body needs to make good rules to follow and then referee the rules of the game. Right now, we have no rules and no referee, and we need your help. The barn door has been left open for nearly 20 years in our state with no rules and no regulations to speak of, with the exception of the Flint Hills ban. It is time to close and guard the door until there are protections in place for every citizen. SB 2323 removes some of the very aggressive tactics that companies use to take advantage of uninformed landowners. Some who are elderly have no idea what they are signing. All they see are the dollar signs. We actually know people in McPherson County who signed leases who didn't even read the lease before they signed. The citizens of Kansas who have fought these projects know that we need openness, honesty, and integrity. We do not need behind closed door bribes, threats, bullying, and intimidation of Kansas landowners and our elected and non-elected officials by renewable companies and their lobbyists. Government should protect people and regulate corporations, not the other way around. Right now, in my opinion, we're protecting corporations and regulating people. When I listened to testimony regarding HB 2381 last year, Kimberly Savati of the Advanced Power Alliance stated, Kansas wind power provided more than 43.3% of Kansas electric power needs in 2020. Why would we want to add more unreliable, unrenewable, unrecyclable, intermittent energy to our Kansas grid in light of what happened in February of 2021 in Texas, Kansas, and other parts of the midsection of our country? We need more reliable energy, not more unreliable energy. Also, Kansans are forced to foot the bill to transmit wind energy from our state to other states across the nation. Why do we have to pay for that? Every single Kansan in Kansas business is currently suffering from skyrocketing energy costs, and this is bound to continue without regulating corporations. I really believe that the wisest decision would be for our state of Kansas to shut the door for now by imposing a moratorium on all uncommenced construction of industrial wind, solar, and transmission line projects until an energy task force has been formed and has completed its studies and recommendations. Finally, no reasonable and rational person would conclude that 2 to 400 600-foot commercial industrial wind turbines fit the description of our A1 agricultural district that was provided in my written testimony. And yet we've suffered from the onslaught of these commercial companies for nearly 2 decades. 2 decades now. Enough is enough. I thank you for your service to our state of Kansas, and I ask you to give careful consideration to SB 323. I give my support to SB 323, and I ask that you on the committee consider doing the same. I invite you all to join in the discussion on our Citizens for Responsible Agricultural Land Use Facebook page. You can find the page by searching the name provided at the top of my written testimony. Am I out of time, Mike?
You are just out of time. Thank you, Bev. We appreciate that. So committee, we've heard from our 2 proponent in-person conferees. We also have written only that you can find in your packet and online from Shirley Estrada, who's a private citizen, Roger McCowan, who's over in Washburn School of Law, and Kathy Nicholson, a private citizen. And I would like to open it up to questions from committee for any of the 2 in-person conferees. Any questions, committee? Senator Francisco.
Thank you, Mr. Chair. So when I'm reading this bill, part of it, and we heard a little bit about this, the part that prohibits the landowner and the developer, the owner and the operator of the facility, for collecting any fees for hunting. People lease parts of their land or layers of their land. Why would the legislature want to interfere with the landowner's right to lease property or collect fees?
I can answer part of that, but I think I'll turn it over to Bill Scott. Bill?
I'd be happy to answer part of that. The easements that are inherent in these leases are exceptionally broad. So part of what happens is they have the right to limit use of the property. And that includes hunting, fishing, agriculture. If they're installing substations, windmills, high-density windmills, whatever they don't want people shooting guns, shooting arrows, so they can limit you from using it. And what's problematic in the language that's in those easements is they're very, very, very broad. So they would have the ability to limit about anything they want to do on the property. And what's even more scary beyond that is they could take, if you signed a lease agreement with an industrial wind developer, per the lease that I reviewed that was down in Lynn County, they would literally have the right, prior to even completing a development, to drop all your acreage off of that development, not install any energy or income generating device that would benefit you, but still maintain a broad set of easements on your property for the life of the lease in case they decided they wanted to do something later, put in roads, whatever it may be. So it's problematic, and hunting is one of the things that is restricted. So if you were to want to hunt on your own property, you may be limited, and you would probably be limited from leasing that to anybody to hunt as well because of the language that's in those easements.
Mr. Chair, if you object to the language in those easements about the restriction on landowners, why are we putting restrictions on the landowner in this statute? This is not just the developer. This says it prohibits the landowner from collecting those fees. And so I'm wondering, if we're objecting to companies doing that, I'm not sure why the Kansas legislature would think that that's within our purview.
I'm not sure I can answer that question accurately, but again, the scope of the easements are such that if a landowner enters into a land lease, they've given up that right at that point, and somebody else is in control of whether they have the right to do that or not. So limiting that privilege to lease it would likely have an impact only on the industrial developer because they're the ones that take control of it by virtue of the easement.
Mr. Chair, then I'd rather rewrite it that way.
Thank you, Bill. And I think part of the problem is Kansas do get paid, landowners, for walk-on hunting, but the leases restrict hunting. So why would Kansas pay a landowner for walk-on hunting when they're prevented from doing so in the lease? That's a protection from double dipping, essentially, for something that they're not going to even be able to do.
Be a direct conflict with what they agreed to with the state as well.
Exactly. And that's the reason for that particular clause in this bill.
But I think it's making some assumptions of what's in a lease, and we don't know that, and we don't have any control of that. But let's go on.
Bill has the lease. I've seen other leases too, and they all prohibit hunting.
And the lease that we reviewed is one that was used in developments that exist now in southern counties, Neosho, Allen, same lease. And 15 of those were signed in Lynn County. Thankfully, the development did not commence.
Senator Olson?
Yeah, we're really talking about private contract laws. I mean, when you're entering into that lease, you know, you should be knowledge or have someone hired of knowledge to understand what you're signing away, but that's
Absolutely.
still the
Absolutely, but-
landowner. You didn't, you know, that could be a negotiation in the lease that you don't waive your rights to being able to allow someone to go in there and hunt. I mean, they're being paid for them easements. So I don't know that that's someplace here for us. Maybe I'm wrong, but.
I'm not sure if I understand your point. Is it that the landowner should know what they're entering into when they enter into the lease?
I think so.
Well, I would agree 100% with that. And that's exactly the purpose of this bill, is to make sure people understand if you're going to enter into this lease, you need to have your eyes wide open to understand what you're entering into, because it's a very onerous agreement that is very lopsided toward the energy developer. In my perspective, to kind of summarize it up, so again, this was reviewed by an attorney, okay? So it's not just some guy who's not an attorney trying to give a legal opinion on it. When you enter into that agreement, you are, for all practical purposes, granting use of your property and almost exclusive use of your property to that developer with limited return rights of what you can do on your own property. And I think a lot of landers simply do not understand it. It's a 57-page agreement. You can tell that they've pushed every imaginable thing they've probably run into every court case in the last 20 years into this agreement to try to indemnify themselves from any responsibility once they put it in. And it's mind-boggling to think that you could be limited from fishing or hunting on your own property, but they have the right to do that in the easements.
We'll wait and see what the other side has, but in my opinion, you know, it doesn't matter with this bill or without this bill. I would definitely probably consult a lawyer or
Absolutely.
thoroughly read it to understand what's in it. I wouldn't sign it.
Yeah, absolutely. I agree with Senator Olson. I agree with you
And I
100%.
don't think it's our place to put restrictions on what landowners can do.
Well, again, I understand that, but that's what zoning does.
Senator Bowers?
Thank you, Mr. Chairman. Hi, Bill. Just a quick question. Do you have any idea of how many people don't have a lease reviewed by their lawyer? Is it?
You know, I do not know. I
Maybe
can
there could
only
be some,
speak
but-
to my limited experience in Lynn County. There were, the last I knew of, there were 15 property owners who had executed leases with the RDBA. And those were filed at the county level. I can tell you that there were several that I know did not read them. I would be willing to bet all 15 of them didn't understand what they signed. You know, we had held some public forums just to try to get education out there so people understood it. And people were taken aback when they finally at least had some reasonable understanding of the scope of the restrictions that they granted via the lease. So, you know, they're rural farm people and rural people in general, and I don't mean to generalize this in any negative way, but tend to be trusting, have lived their life on a handshake. You know, these agreements are written in such a way that those people could sit there and tell you in front of every one of you that they're going to put 15 windmills on your 600 acres. You sign the agreement, and then as soon as you sign that agreement, the disclosures and the disclaimers in that agreement nullify anything they told you, and they don't have to put one in if they don't want. But they have control of that property as part of the giant footprint and all the easements necessary to run power lines, transmission lines, roads, whatever they think they need to do on it. And I think the problem is most people don't understand the scope of the problems that they're entering into. And it's generational. You're talking about a 39-year lease or 37-year lease. You know, most people that sign that will probably be passed away before the leases expire.
Well, thank you for your comment. I truly believe I would tell any of my constituents to have it reviewed by a lawyer. I
Absolutely.
certainly tell my kids any of that and my neighbors. So from where I come from, I think lawyers do look at these leases, and it's, to me, that's a very important part of the process. And I would hope that we continue, if it's education, we do that, but certainly a lawyer should look over every lease. And
I absolutely 100% agree with you, because that's the only way to know exactly what you're entering into, and at least you've gone in with your eyes wide open. 100%.
Thank you, Bill. Thank you, Mr. Chair.
Welcome.
Thank you. Okay, Bill, we need to get on to our opponent testimony. Thank you very much. And we have one in-person opponent testimony, Josh Swati, Kansas Advanced Power Alliance. And Josh, you've got 10 minutes.
Mr. Chairman, Mr. Vice Chair, Madam Ranking Minority, members of the committee, it's a pleasure to be here. I know that you are used to seeing Kimberly up here, so this is a new territory for me, and for my sake, I hope I do well today. But anyhow, thank you for the opportunity to testify on Senate Bill 323. When members of the Advanced Power Alliance, particularly developers, go in to build a wind or solar installation in the state of Kansas, we are looking for three things. First of all, do we have a great resource, which Kansas statewide generally is good for both wind and solar? Two, do we have access to move that power to market? Typically, that's access to transmission lines. And then three, and this is most important because wind and solar installations are not utilities. They do not have the power of eminent domain. We have to have landowner interest. There are more than 40 operating wind farms in the state of Kansas. All of them exist because there were private landowners that wanted to enter into private contractual leases with the developer to have a wind farm on their property. It could not be any other way. And on top of that, I would add to the committee, if there were problems in those leases, and you know better than I do, the state of Kansas is a very popular pro-hunting state. If there were problems in those leases that prohibited landowners from doing what they thought they would be able to do, you would have now, 20 years later, seen this room filled with people saying, wait a minute, this lease isn't operating the way I thought it would operate. But that is simply not the case. Those contracts are crucial to how we develop in the state of Kansas. Another important aspect of those contracts that I would bring up as a member and a former member of the legislature, as they are private, between two private entities, we should never casually try to mess with them at the state level. This is a fundamental element of free enterprise. I can remember only one instance when we dealt with something for the oil and gas industry in the House Utilities Committee in my time, 7 years in the legislature, and it was because, and this is crucial, it was because one of the members of either of those two parties had come forward to the legislature after multiple court cases and said, there's still some confusion, can you provide some clarification after all of this case law couldn't give us the clarification we needed. If you are going to mess with contracts, I would argue that it's important. It is because one or both of those parties has come forward to you. Members of the Senate Utilities Committee, I would argue that Senate Bill 323 is before you, irrespective of either of those two parties, either the developers or the thousands of landowners that have entered into these agreements. So before I run out of time, I want to make sure I address some of the mechanical problems of the bill. It was mentioned by the reviser at the beginning of the hearing that this would only be prospective. And I'm nothing against the reviser's description, but that's true of unbuilt projects. But it says prior to construction, these must be met. There are thousands of leases currently in the state of Kansas that would be declared void. And so I cannot imagine how much fun it will be for someone to go out to Kansas landowners, private property owners who have freely entered into these agreements and have someone say, oh, by the way, this lease that you have, which you received money for, is now no longer valid. So prior to construction refers to thousands of leases that already exist in the system, but those projects may not actually be built. Secondly, the language regarding a cover letter in 16-point font saying you need to go out and get an attorney. I can tell you, as a person who has interacted with these developments for years, we approach all landowners as though they are John Dutton. If you're familiar with the TV show Yellowstone, the fictional character that spends all of his time protecting the private property rights of his ranch in Montana. But for sure, not all landowners end up like John Dutton, but let me give you some examples. Some of them immediately take that lease and hand it over to an attorney. They don't even look at it. They say, my attorney's going to look at it. Some of them say, you know, I'm going to negotiate with you and I'm going to do better negotiating than an attorney would. And in some cases, they are really great negotiators. Some of them, the land agents for the developers themselves say, hey, you really need to look at an attorney, or you can take this to an attorney. Please, you need to have them look it over. And guess what? The landowner will continue to say, you know what? I am never taking this into an attorney. I'm going to do this on my own. That is their right, because this is a private contract between two private parties. Moving on, the non-disclosure agreements, there is no non-disclosure agreement prior to any contract being signed. If you haven't signed anything, you can talk about it as much as you like. On top of that, most of these developments start because of a public meeting where landowners are brought together to gauge interest. And so there is already no non-disclosure problems pre-contract. You can't have an NDA without having something signed. New section 1A4. Facility agreement, as Senator Warren pointed out, is not defined. We don't know what that is. New section 1.4b on the element of hunting that was pointed out in questions. Hunting is allowed on properties, and guess what? Most of the time when a landowner is met with a land agent, the first question of that landowner is, can I still hunt? And the answer is yes, and they can still lease it. There's usually a prohibition on hunting during the construction phase, which would make sense. Also, in the case of a solar lease, there tends to be a prohibition on hunting, but I'm sure you could imagine a solar lease is different than a wind lease because those land uses are very different as well. Those landowners that lease for solar understand that it's a very different land use. Wind generally allows the agricultural productivity or whatever the land is being used for to continue on. Solar, if you lease for solar, it's a much more dense footprint, but for sure, I'm sure the committee can understand why a solar installation might not want someone going up and down the rows with a 12-gauge shotgun. Finally, the remainders of that piece of legislation are all about elements that have been established already in case law. Kansas is lucky enough to have more than 140 years of case law dealing with lease arrangements, largely with oil and gas. But if there are questions, the courts are the ones that tend to hammer out exactly what that lease language means. And so then the only thing left would be, as the two proponents talked about, those elements or those governmental bodies that could have some say over this. And I would point out to this committee, In terms of case law for wind and solar development in the state of Kansas, the most important case was Zimmerman v. Wabunsee County, which said very clearly the counties have the right to make the determinations on these wind and solar installations. And I would also point out the two proponents in person, we're speaking of McPherson County and Lynn County, both counties that have chosen to have a moratorium on wind development in their counties. So the system is working just fine. If a county wants to have a project in that county, they are welcome to. If a county does not, they do not have to do it, and they are well within their bounds to choose that they don't have to. But I would argue in closing that before we begin to meddle with the language of a private contract, I would urge this committee to leave this to the two entities that are engaging in that contract in the first place and stay well outside of that free enterprise. Thank you, Mr. Chairman.
Committee, any questions? Senator Warren.
Thank you, Mr. Chairman. I've been an avid proponent of private property rights. I just want an accurate discussion of the bill, and I have two questions actually for the reviser based on some testimony that we just heard. One was that if this bill were to be enacted, that it would negate leases that were signed before this bill becomes law. Is that accurate?
Mr. Reviser?
Yes, Senator. The conferee pointed out that the language in the bill states that prior to the construction of any facility, and I believe the issue that the conferee was referring to is that there are agreements already out there, and construction has not began yet. So there's some questions that the conferee is bringing up regarding the validity of those instruments that have been entered into prior to any construction.
Go ahead. I don't mean.
No, I was.
So we have a written agreement that's in existence prior to the enactment of this law or any law. It doesn't seem accurate that the law would apply retroactively to such a written agreement unless the law specifically says this applies retroactively, which this bill does not. So I still question the accuracy of the statement that if this bill were to become law, that it would affect prior activities before the bill would become enacted, if it would become enacted. And secondly, there was some other testimony that the bill somehow requires a landowner to hire an attorney. I don't see that anywhere in the bill. When we're looking at the special message to property owners, that it doesn't require that. It says at lines 20 through 22 on the first page, you and your neighbors may choose to hire the same attorney is what it says. So I just thought it would be helpful for the committee and for those listening online and in the committee meeting room that we have accurate discussion about what the bill says and what it would require. Thank you, Mr. Chairman.
Thank you. Any comment on that, Nick? I think you good shape. Okay. Any other questions, committee? I do have a couple. Josh, were you here during the hearing last year, Senate Bill 279?
I would, yes, I think so.
Yeah.
If I wasn't in the room, I was sitting outside.
A lot of those people, quite a few that showed up, were concerned over the fact that there were gag orders on the lease. They signed the lease. They couldn't talk to their neighbors about it. And a lot of times the wind companies will very quietly sign these leases, then go to the county to get a special use permit after the fact, so that what happens is a lot of people are not aware of this. This bill, wouldn't you agree, just encourages people to seek an attorney's consult or advice and gives them time to consider it before they sign. I mean, I think some of these other things you brought up we can clean up, particularly Senator Francisco's, but wouldn't you agree that it's a good idea for people to have a little time? And I've had some elderly people who have complained that they've been pressured by multiple visits by wind companies to try to get them to sign, and they feel like they're under duress.
First, to Senator Warren's point, that is correct. Yeah, it doesn't say you have to have an attorney. It encourages you to seek out an attorney. And I think from our perspective, just more broadly, why would the state want to begin requiring lots of little extra add-ons to any contractual situation? And the larger question of, does this influence previous leases or not? I think from testimony on this bill and others, it would indicate that there are people in the state of Kansas very unsupportive of private property rights that would be willing to litigate this ad nauseum, suggesting that it does go backwards and influence those, whether or not that ends up being the case. So to your question then, Mr. Chairman, I think that a state government body trying to regulate or protect private landowners when this may or may not exist. I can't speak to all of the people testifying and whether or not they had duress, but I can speak loosely on contracts in general, and that there is always remedy if you were in fact in duress, and you can go to the courts if you feel like you signed that somehow in duress. But for the legislature to try to solve that when it appears that that might not be a big problem. I mean, we have more than 40 operating wind farms, and we're just not seeing a lot of landowners coming forward saying, boy, 10 years later, I really regret this. Then why would we suggest now that we should do something and that they are somehow under duress off of just some comments or opinions that we hear from a few individuals?
I would say that I've seen some of these leases, and there are confidentiality agreements, and as a result, that's why you're not seeing some of these people coming forward.
And I apologize, I didn't address the first part of your question on the non-disclosure agreements. Non-disclosure agreements are part of almost every contract. Usually it's to protect proprietary business information, or in the case of leasing, landowners are incredibly savvy. And if they were able to look at every aspect of their neighbor's lease, it would become a rapid bidding war when they were putting these together. And back to the other part of that first question, you know, they seem like they just happen really early. Just to give some background on how these usually come about, typically, a local landowner wants a wind farm or a solar farm, and they contact a developer and say, hey, I am interested in doing this, and I've got some neighbors interested in doing this. Would you come down and have a landowner meeting? And so the developer then starts doing site studies. You know, is this a person that wants a wind farm, but it's not a really good place? Or maybe it is. We should go down and have a landowner meeting and potentially begin the process of leasing. But the reason leasing is early is back to my original point. You have to have a quality resource, you have to have quality transmission, and then you have to have willing landowners. Is it's not worth the company's time putting in a lot of development effort if there's not landowner interest in the first place. Why would they expend all that money on a site if there wasn't landowner interest? They have to find out if there's landowner interest.
Committee, we are out of time for questions. Sorry about that. I do apologize, by the way, committee. My original rules for the committee would be that we start on time at 1:30, and I think we're going to go back to that in respect for the conferees, attendees, people online. So going forward, I'm going to try to start this at 1:30 sharp. I understand our committee happens after lunch, and that's a problem, but just so you know, we're going to get started on time every day, and I appreciate that. Tomorrow we'll have a hearing on Senate Bill 234. Appreciate everybody coming today, and with that, we are adjourned.